In civil law, a statute of limitations sets the deadline for filing a lawsuit in a particular jurisdiction. Each jurisdiction sets its own statute of limitations period. But if a plaintiff is injured in one state and files a lawsuit in a different state, which jurisdiction's limitations period should apply? The Wyoming Supreme Court considered this question in Duke v. Housen. In April 1970, Margaret Housen met Pony Duke in Virginia. That evening, Housen and Duke engaged in sexual intercourse. After Duke professed his love for her, Housen met him in New York and accompanied him on a cross-country drive as part of Duke's job as a truck driver. The couple engaged in sexual intercourse in several states during their journey. However, Housen was unaware that Duke was being treated for gonorrhea at that time. Once the trip concluded, Duke ended their relationship and returned home to Wyoming. The couple later met in New York and engaged in sexual intercourse during a brief reconciliation. The following morning, Duke admitted that he was receiving medical treatment for gonorrhea. Housen visited her doctor in Virginia 2 days later and learned she also had the disease. In 1973, Housen underwent exploratory surgery to investigate unexplained abdominal pain. The surgeon informed Housen that secondary infections had resulted in abdominal adhesions that would continue to form for the rest of her life. In 1974, Housen filed a negligence action against Duke in Wyoming. The trial court rejected Duke's defense that Housen's action was barred by the statute of limitations. The court ruled that Wyoming's 4-year statute of limitations didn't begin to run until Housen discovered the adhesions. After a trial, a Wyoming jury awarded Housen $1.3 million in damages. On appeal, Duke argued that the trial court should have applied the statute of limitations of the state where Housen's injury occurred.